response to defence submissions that there was simply no power, that this was ultra vires, the UN Security Council, the court said, no, that phrase, necessary measures, the need to restore peace, fear for international security, entitles us to do anything we like, and that can include saying that a court will be established to try those most responsible. It's a famous decision, the biggest decision post-Nuremberg, probably the biggest decision in international justice, actually, with Tadic jurisdiction. The green light was given for international courts through the UN exercising its authority over an area where there had been a failure to prosecute or a lack of capacity to prosecute. So life moved on, and the Security Council Resolution 827 in May of 1993 was given the green light and said to be a proper exercise of this new power to prosecute individuals at an international level through the UN. The International Court of Justice we looked at right at the beginning was a court that was established in the actual UN Charter of 1946. And that was to resolve disputes between states. No such provision was made for a criminal court, but the court here made its own law. In other words, the judges didn't vote themselves out of the job, which I always thought was going to be the likely outcome of the submission. And no one in the building was going to go home tomorrow and close down 500 jobs. And so international justice rolled on. And so having made that decision, this model triggered by the powers under Chapter 7 has become a well-used model throughout the world, and also used with national jurisdictions, even in a context where international security isn't threatened. They've rather stretched how far they can go with it and what the meanings of international security are. But we've seen in Sierra Leone a national court set up with UN help under Chapter 7. Now, let's look at the International Criminal Court. What does that mean? How do you get there? You can be a member of the International Court Club, rather like the MCC. Kenya had signed the Treaty of Rome, and when it had conflict within its territory that it had allegedly failed to deal with, it was alleged to be so serious that it had to go up to the ICC. It found itself having individuals prosecuted. The jurisdiction isn't against the state itself or against the army, it's individuals. They're the only ones that can be prosecuted. So, being a state party, you've signed up for it, you've given away your jurisdiction. Great Britain has, but the Americans haven't, Russians haven't, Chinese haven't. That then can make you liable for prosecution for serious crimes that we've looked at. Another way is because the UN, which is a body that supports the ICC, even though members of the Security Council, like US, Russia, China, are not members of the ICC, the UN Security Council can refer a situation to the court and say, look at it, investigate it, and if necessary, prosecute it. That's what we had with the Darfur situation in Sudan, where the Security Council said there are too many people dying here, there's too much conflict, and referred that situation to the ICC, even though Sudan was not a member. Or a state can turn itself in, refer a situation, even though it's not a member of the ICC. Ukraine has done that recently, and referred the situation there. So a state says, as indeed the Democratic Republic of Congo, we have a situation here, we to investigate and prosecute those responsible on our behalf. And so that situation is referred. Prosecution can investigate whatever they like. They have that wide mandate, because if an individual of a state party to the ICC statutes, say a British guy in an area of conflict somewhere around the world, has committed a war crime, genocide, crimes against humanity, because his mother country is signed up, he can be prosecuted. So people with dual citizenship can be caught by the ICC statute. And then you can have national legislation setting up particular courts. We've seen that in Sierra Leone, where Desmond was the prosecutor, Cambodia, and these are hybrid courts which are set up with UN support, but their founding statute is on the national legislation books, but they bring in UN judges or international judges, they bring in international prosecutors, because they are not able really to fulfill their mandate. East Timor did that, the Sierra Leone did that, and they brought in defence lawyers, and there was a defence office, etc., that were brought in so that the cases could be heard properly. So national legislation can achieve the same. Some courts make their own, like Bangladesh made its own International Crimes Tribunal in 1973. A homemade effort. It was actually drafted, their statute, by a friend of mine, but they altered the text of his words to be rather less favourable to the people they were prosecuting, and to reflect that they were only going to prosecute one side and not the other side. So they subverted, if you like, the blueprint for their court, and that's got them into a load of trouble internationally and affected their reputation. So you have to do it even-handedly, you have to do it according to international principles, otherwise you're not really fooling anyone. Let's now move on to the last couple of matters which are of interest: evidence and testimony. International criminal courts don't follow the common law model, and hearsay is admissible. There are rules of evidence that allow the receipt of as much material as possible for the judges. This was an example in Nuremberg. The first live witness at the Nuremberg trial was only called on day 9. The previous 7 days had all been counsel just putting in boxes and files, schedules of evidence through counsel, not agreed with the defendants, but just boxes of evidence without any witness or otherwise. So standing up to say, oh well, someone's got to produce this, or this is hearsay, gets you nowhere in an international court. The judges like to see everything, and so it's even an enhanced development of that form of criminal procedure you'll find in the civil code jurisdictions. An example of this was the confirmation of charges hearing in the Kenyatta case, which was contested prosecution, just summarised evidence. You didn't even have to show the judges full statement, just a summary of it. 5 lines, highly misleading, and not the truth of the statement. So a very difficult one for us common lawyers to get used to and indeed accept. And so you have to unpick that kind of problem. In fact, the test for admissibility is whether it's probative, simply that in most courts. They will rule out evidence if the defence can make an application in sufficient time. You've got to make it in advance when when the evidence is first served. So if you delay, you'll lose your argument. But you've got to show very good reasons why such evidence shouldn't be admitted. Let us now move to the last matter, which is a legal issue relating to these courts, are witness protection issues. In the first case I did, the Dusko Tadic case, virtually all evidence there was live, it was on TV, everybody saw it. Now move the clock further on, some almost 20 years now, 19 years, to the Kenya trial of William Ruto in The Hague at the International Criminal Court. No one has seen a witness there for months, a year in fact. They haven't had a live witness for the public to see. All shrouded in witness protection measures. All images of a witness are distorted, voice distortion, so there is lack of public accountability for what the witness is saying. Highly dangerous. Again, the prosecutors know that they are playing. You'll hear more about it when the kind of games they play in the third lecture of this morning when we turn to look at what happened in the Kenya case. Because it's a problem that you get false witness syndrome and you also get fabrication of evidence and lack of accountability. I've spoken now for exactly an hour. Jill Higgins is going to take over as we move the debate on. And we'll leave questions to the end, I think, so that we get through the material.
Thank you very much. We will have some limited questions, but at the end, I think. So I'm going to invite Gillian to address us now. We are running a bit late. What I've suggested, and Gillian has kindly agreed, is that she'll start and perhaps break off, she says she doesn't mind doing this, at about 12, and then we'll have a shortish coffee break, please, from 12 to 12:15, and then the rest of our program before lunch. Thank you. Gillian.
Thank you for having me today. It's been now about 5 months since the election of President Sirisena, with his 100-day action plan of how to right the alleged wrongs from the days of President Rajapaksa. And we're at a very exciting time potentially for Sri Lanka, as Sri Lanka is poised to commence what President Sirisena has called a domestic investigation into international crimes, which ended in 2009, closely watched by the rest of the world. The thorny question of whether, and if so how, a state deals with these sorts of crimes is riddled with requirements to observe international obligations, political sensitivities, and how to ensure a fair and impartial process that is, most importantly, going to be accepted by Sri Lankans. And that is, of course, no easy feat. As all of you know, in March of last year, the UN Human Rights Council had voted to investigate the war crimes itself. This was a step welcomed by some, but wholeheartedly rejected by others. At the time, you'll recall that President Rajapaksa had refused to cooperate, and his notion was that, in fact, this was merely the West pushing hidden agendas, and it smacked of potentially a form of legal paternalism for some, that Sri Lanka was being highlighted, and also Sri Lanka was being told how these crimes should be investigated in accordance with international standard, which somehow implied that Sri Lanka was incapable of doing it itself. The President's view at that time was that Sri Lanka was effectively being bullied by Western powers over how it had handled its post-war reconstruction and reconciliation efforts between the different factions. Foreign Minister held a similar view, made it clear that there was no justification for the disproportionate attention that Sri Lanka and its problems were somehow attracting. However, things changed somewhat with the election, surprise election, shock election for some of President Sirisena in January of this year. And I was fortunate enough, as I know many of you were, to be in Sri Lanka at that time. And one of the questions on many people's lips was, what will Sirisena do about the UN? And how will he reconcile this nation? And how will he ensure that the people of the nation accept what he comes up with? Well, he had promised, as we know, this domestic investigation. For me, I suppose, as an international criminal lawyer, I'm desperate to know how it's going to be done. And I've searched the media, searched what I can find, to find very little at the moment in terms of the detail of how it will be commenced, how it will be funded, how it will ensure a fair approach to the inquiry that is due to take place. And more importantly, perhaps, in which ways will the fruits of the investigation be processed? Is there a larger plan of transitional justice for Sri Lanka? What will happen to the results of the investigation? Will they be squashed and squeezed into some form of ultimately internationalised tribunal, or will there be some effort to hold more national trials? Or is there a better way? Is it perhaps a better forum for there to be some form of truth and reconciliation? Because perhaps the pain of the crimes that have gone on for decades is simply too great to withstand further prosecutions in perhaps the normal criminal justice manner. Well, shortly after his election, following a request from Sri Lanka, the UN deferred the issuance of its report until September, confident that given the changing times, Sri Lanka needed its own time to put into effect its own plan. Meanwhile, President Sirisena has taken his time to try and mature what he refers to as this domestic investigation. He also, like Rajapaksa, was not convinced that an international analysis and an international investigation was in fact the appropriate way for dealing with Sri Lanka's past in a restorative and sensitive manner. He has said that UN investigators' views will be taken into account, but to what extent and how remains unclear, as does the structure, procedure and intended machinations of this investigation process. Well, the ways in which he may draw upon other investigations and other tribunals may merit us pausing to consider. You've heard some of the types of crimes that have been processed by different states facing similar problems, similar conflicts. But it may be worth, perhaps, in the next half an hour, over a coffee break and thereafter, to simply resume the different types of courts, tribunals, and some of the failed mechanisms as well. Because it seems to me, having looked at the situation, it isn't one where we're going to be looking at recreating another ad hoc tribunal or another internationalised mechanism. But it seems to me that consideration needs to be given to how best the fruits of that investigation may be suited for Sri Lanka's own purpose. And what I want to come on to end with is looking at the aims of transitional justice, which is reconciliation, and ensuring that the country moves on, having dealt with its own conflict in a manner which is acceptable to the people of the country. So, before we take coffee, perhaps we can just we go back where our journey commences, as Stephen has mentioned, and that really takes us back to the Nuremberg and the Tokyo tribunals. at the end of World War II. The resolve there was not restorative. The resolve was to punish, very clearly to punish leading Nazi war criminals. And as you've heard, the International Military Tribunal in Nuremberg held one trial of 24, originally 24 defendants selected from a high level of German diplomatic, economic and political leadership. Highly sophisticated professionals, a relatively small number when one considers the framework of the war. One, Krupp, was excluded due to his failing health. Another, Bormann, was tried in absentia. And another, Lee, committed suicide in prison on the eve of the trial. So 21 were left. Hitler, Himmler and Goebbels similarly committed suicide before the end of the war, or thereby near. It was decided not to venture into trying them posthumously, although that question was considered. It took place in front of international judges, as you will be aware, and there was also a twin tribunal in Tokyo which sentenced 7 Japanese leaders to hang, including the Prime Minister, and the jailing of 18 others. Emperor Hirohito was not prosecuted, as it was felt by the Americans that any attempt to do so would have prolonged the war in the Pacific. The criticisms, as we know, were many, and we're still learning from them as we seek to find new methods of transitional justice. The main criticism was that the IMT and the Tokyo Tribunal were simply institutions of victors' justice. There was also the criticism that the law that was being applied was ex post facto, particularly in respect of crimes against peace, where it was not considered by many that there was a sufficiently formulated body of law to justify using that crime at the time. German Defence Council complained, as we still do today, that there was a lack of time to review the enormous amount of paper disclosure in that case. But what it did do was set a framework and a standard and a belief that such crimes could be prosecuted. This could be done, notwithstanding the criticisms. Superior orders were not a defence. Nuremberg did away with the umbrella, the protective umbrella of state sovereignty, and again ensured that these sorts of crimes and people could be tried. Official position of defendants was irrelevant. And interestingly, there was also the prosecution of groups or organisations. So a new world order had begun, effectively, of international prosecutions. That was there continued after by many more trials under Control Council Law 10 and by the Americans, in which several more, I think it was 142 of 185 defendants that were tried in that process were convicted of one or more count. Behind the scenes of the two tribunals, which is very little spoken about or known about until recent years, is the work of the UN War Crimes Commission. So during the war, this body that had been set up by 17 allied nations began its work in 1943 by collecting information about potential crimes, reports that had come to the Commission about crimes that were being carried out. And it carried out an incredibly important function of putting together a body of individuals to be prosecuted and evidence of crimes that had been committed for national prosecution then by those states. Little is known about it, more is becoming known about it due to a project that is engineered by SOAS University to try and put on the internet and to electronalise the documents that we have in hard copy so that we can start to benefit from their wisdom back in the 1940s. So there was, at this very early level, a very early time, this distinction between accepting the prosecution of high-level individuals at an international level but then seeking the prosecution of others within the national states, something that we are still striving to obtain